Defense Symposium, brought to you by Trident Defense. Before we begin, may we request everyone to please stand for the Philippine National Anthem. Thank you. You may now take your seats. So again, welcome to the Special Defense Symposium hosted by Trident Defense. I am Esmeralda Cruz.
And I'm yours truly, Attorney Jose Adolfo B. Cruz.
And we are your hosts for this afternoon. So the decision on this arbitration was really looked forward and anticipated by the international and even the local community.
That is correct. In fact, Trident Defense was supposed to hold the follow-up symposium next year, following the one that we just conducted last month. However, we found a compelling reason to organize this special defense symposium due to the recent issuance of the decision by the Permanent Court of Arbitration at The Hague.
And we all know that the decision is a very big thing for not only the Philippines, but the international community, hence the very diverse audience today. So may I request my co-host, Attorney Cruz, to please introduce our dignitaries and special guests.
This afternoon, we are honored by the presence of the members of the diplomatic community. In particular, we are grateful for the presence of the ambassadors to the Philippines of Singapore, Panama, and Greece. In addition, we are also delighted to have representatives from the following embassies: from China, from the United States of America, Japan, Vietnam, Indonesia, Thailand, Myanmar, India, Turkey, Australia, New Zealand, Mexico, France, Italy, and Saudi Arabia. On the part of the Philippine government, we are honored by the presence of Associate Justice of the Supreme Court, the Honorable Mariano del Castillo. We would like also to acknowledge the presence of Undersecretary Vice Admiral Luis Alano, who is the Executive Director of the National Coach Watch Council, Defense Assistant Secretary Roy de Vera Turda, who is representing the Secretary of National Defense. We are also grateful for the presence of officials from the Department of Foreign Affairs from the following offices: the Office of the Undersecretary for International Economic Relations, Office of the Undersecretary for Policy, Office of the Undersecretary for Migrant Workers, Office of the Public Diplomacy, Legal Affairs, the UNIO, or the United Nations and other international organizations, Office of the ASEAN Affairs, Asia Pacific Affairs, European Affairs, and the Middle East and African Affairs. We're also delighted to have representatives from the Bureau of Fisheries and Aquatic Resources, led by its Director, retired Coast Guard Commodore Eduardo Gongona, and from the Armed Forces of the Philippines, we would like to welcome Major General Guillermo A. Dolina Jr., Deputy Chief of Staff for Plans and Programs of the Armed Forces of the Philippines. We would also like to welcome Rear Admiral Ronald Joseph Mercado, Commander of the Western Command based in Palawan. We'd also like to welcome a good friend and a classmate, Colonel Serme Ayuyao, the Judge Advocate General of the AFP, representing the AFP Chief of Staff. We'd also like to recognize the presence representatives from WESCOM, NOLCOM, the Office of the Naval Strategic Studies, Office of the Ethical Standards and Public Accountability of the Philippine Navy, the AFP Media and Civil Affairs Group, and the 7th Marine Brigade. From the private sector, we are also delighted to have representatives from private corporations and chambers of commerce, the Institute of Maritime and Ocean Affairs, the Maritime Law Association of the Philippines, the Integrated Bar of the Philippines, private law firms, Kalayaan Atin Ito Movement, the National Youth Movement for the West Philippine Sea, the Pamalakaya, bloggers, and social media personalities. The academe is also likewise represented, led by Father Rangelio Aquino, Dean of the San Beda Graduate School of Law, who will be one of our reactors. And also we have attendees from several law schools, from Arellano, from San Beda, De La Salle, UST, MLQ, and the University of the Philippines, led by the representatives from the UP Alliance of Responsive Involvement and Student Empower, or UPRIs, and the UP Engineering Student Council. We are also delighted by the presence of students and teachers from the high school department of Lourdes School of Quezon City. Of course, we would like to thank the Office of Senior Associate Justice Antonio Carpio, led by Attorney Maria Teresa Cibulo. We hope that you are all settled, and as we look forward to the lecture and fruitful discussions thereafter. So have a good day.
So to formally begin, may I call on Rodrigo C. Mejia, MNSA, the Chairman and CEO of Trident Defense, for his opening remarks. So may we give him a round of applause.
Well, a pleasant afternoon to all. It is with great honor that I welcome our guest lecturer for today, the Honorable Antonio Carpio, Senior Associate Justice of the Supreme Court of the Philippines, the Department of National Defense, represented by ASEC de Verturda, the academy represented by Dean Rangelio Aquino, the Dean of the San Beda College of Law, the Department of Foreign Affairs headed by Yusek Manuel Tihanki, foreign diplomats representing 18 countries, the defense attaché of many countries are here, the Integrated Bar of the Philippines, distinguished guests, and every attendee here to the second annual Trident Defense and Security Symposium. Trident Defense is a think tank group that advances study in the field of international security and geostrategy. It advances security, peace, and cooperation through strategic consulting, policy counseling, research analysis studies on a comprehensive range of defense and security issues. It addresses strategic issues and threats confronting US, China, Japan, Korean Peninsula, Southeast Asia, and the whole of Asia-Pacific region. Its mission is to inculcate wise strategic thinking among leaders involved in the defense policy making process. Its vision is the realization of these policies in the pursuance of regional peace and hopeful eventual world peace. The strategic challenge that confronts us most today is the uncertainty, complexity, ambiguity, and volatility impinging on national security. National security is a complex domain that remains a key concern to countries worldwide. These challenges can complicate key decisions and turn the tide into a horizon of pessimism and in global insecurity. One of the significant strategic challenges that I see in the next 2 years is the volatile conflict in the South China Sea. This is the Spratly Island. This conflict, I tell you, should be solved in a multilateral or bilateral way so that confrontation between two or more states would be avoided. It is through this symposium and forums that allow us to analyze, debate, devise, or debunk certain defense strategies that do not in any way promote fairness, righteousness, and global responsibility. As chairman of the board and CEO of Trident Defense Incorporated, I thank you all for your attendance. This important event would not be possible without your presence. Thank you. Good morning. Good afternoon.
Thank you very much, Captain Mejia, for the opening remarks. At this point, may we call on the President and COO of Trident Defense for the introduction of our guest of honor and lecturer.
Let us all give him a warm round of applause.
Good afternoon. Born in Davao City, Supreme Court Senior Associate Justice Antonio Carpio finished grade school and high school at the Ateneo de Davao University. He obtained his undergraduate degree in economics from the Ateneo de Manila University in 1970, where he was also editor-in-chief of the Guidon. Justice Carpio obtained his Bachelor of Laws degree from the University of the Philippines College of Law in 1975, graduating cum laude and valedictorian. He was admitted to the Philippine Bar in the same year, ranking 6th overall among all bar examinees. As a private law practitioner, Justice Carpio established the most influential law firm in the Philippines. He thereafter joined the Philippine government as Chief Presidential Legal Counsel and becoming the legal architect of the level playing field policy of the Ramos administration. Appointed Supreme Court Associate Justice on 26 October 2001, Justice Carpio is the chair of the Supreme Court's Second Division and chair of the Senate Electoral Tribunal. Known for the surgical precision and intellectual depth of his ponencias, Justice Carpio penned the decision affirming the constitutionality of Republic Act number 9522, otherwise known as the Philippine Baselines Law, and where he declared, perhaps prophetically, and I quote, "In fact, the demarcation of the baselines enables the Philippines to delimit its exclusive economic zone, reserving solely to the Philippines the exploitation of all living and non-living resources within such zone. Such a maritime delineation binds the international community, since the delineation is in strict observance of UNCLOS. If the maritime delineation is contrary to UNCLOS, the international community will of course reject it and will refuse to be bound by it," unquote. In 1998, Justice Carpio received the Presidential Medal of Merit for his distinguished and exemplary service to the Republic of the Philippines, the Outstanding Achievement in Law Award from the Ateneo de Manila Alumni Association, an Honorary Doctorate of Laws from the Ateneo de Davao University, and the Distinguished Alumni Award for Nationalism and International Law from the University of the Philippines Alumni Association in 2015. Justice Carpio has been traveling the world to present the Philippines' legal position on the South China Sea and West Philippine Sea dispute. Audiences from at least 18 countries and 28 key cities have benefited from his gravitas and intellect. In a few moments, we shall too. Ladies and gentlemen, the chief legal architect of the Philippines arbitration case on the South China Sea and West Philippine Sea, the Honorable Antonio Carpio.
A pleasant afternoon to everyone. I wish to thank Trident Defense for inviting me here this afternoon in this forum. This is the third forum where I was invited by Trident Defense to speak. In the first two fora, I spoke for 1.5 hours each. Mercifully this time, I will speak for less than 45 minutes because before I had to make my presentation in such a way that I can convince the audience that the Philippine position is very strong. But today, the tribunal has accepted all our claims, almost all our claims, so I will just focus on the major issues resolved by the tribunal and how the ruling can be enforced. So the tribunal resolved 6 major issues. First, China's claim to historic rights under the 9 dash lines, of course, struck down by the tribunal. So the status of the geologic features in the Spratlys to generate 200 nautical mile EEZ. The tribunal did not find any island capable of generating an EEZ. The status of geologic features in the Spratlys, whether low tide or high tide elevations. The status of Scarborough Shoal and right to traditional fishing, and harm to marine environment and unlawful actions of China. That's the South China Sea. The 9 dash lines gobble up 85.7% of the South China Sea, including the high seas in the middle. About 25% of the South China Sea constitute the high seas. You have the EEZs of the Philippines, Malaysia, Brunei, Malaysia again, Indonesia, and Vietnam. The 9 dash lines, according to the tribunal, are illegal under UNCLOS and cannot be the basis for claiming maritime zones. All historic rights in the EEZ were extinguished upon the effectivity of UNCLOS. There is no evidence that China historically exercised exclusive control over the waters and resources of the South China Sea. The tribunal upheld the Philippine position on this issue. So, for a country to claim a maritime zone, it must base its claim on land. Marine claims begin on land. The 9 dash lines don't begin on land. It was struck down, and the tribunal said, when UNCLOS was negotiated, everybody agreed that they will have 200 nautical mile EEZ, but they will waive all historic claims to all other areas. And the tribunal affirmed that. That's why the tribunal said all historic rights in the EEZ were extinguished upon the effectivity of UNCLOS. There's no historical evidence that China exercised exclusive control over the South China Sea or its resources. We presented all the maps, all historical records, and of course, Taiwan also submitted an amicus brief, and in fact, that amicus brief helped us explain to the tribunal why Ituaba is not entitled to a 200 nautical mile EEZ. So we go to the next. If you look at this map, those are the waters claimed by China under the 9 dash lines, with the tribunal striking down the 9 dash lines. We now have an area here in the Philippines. Our EEZ is free from the 9 dash lines. All the other EEZs are now free from the 9 dash lines. So the other coastal states, Vietnam, Malaysia, Brunei, and Indonesia, will benefit immensely from this ruling. Let's go to the Spratlys, to the features in the Spratlys. The square marks here with different colors are the features occupied by different states in the Spratlys. And the court ruled that none of the geologic features, rocks or islands in the Spratlys is capable of human habitation or economic life of its own, so as to be entitled to a 200 nautical mile EEZ. The Spratlys cannot be taken as a single unit to determine capability to sustain human habitation or economic life. In other words, even if you consider the Spratlys as an archipelago, the determination of human habitation will have to be per island. To be entitled to a 200 nautical mile EEZ, the geologic feature must have the objective capacity in its natural condition to sustain either a stable community of people or common activity that is not dependent on outside resources or purely extractive in nature. Ituaba, the largest geologic feature in the Spratlys, does not satisfy this requirement. The tribunal upheld the Philippine position on this issue. So when we presented our case before the tribunal, we focused on the fact that Ituaba does not have a fresh drinking water source, because to be capable of human habitation, at least you must have drinking water. Desalination is not allowed. It has to be natural. But the tribunal, in this decision, set the bar higher. The island or the rock must be capable in its natural condition to sustain a stable community of people. It has to be permanent habitation. It cannot be transient. And you cannot rely on outside support. You must get all your resources within the island in its natural condition, so you cannot put up a desalination plant. This means that in the entire South China Sea, well, the tribunal already ruled there are no islands here capable of human habitation. That will also apply to the Paracels and to the Pratas. None of these islands will satisfy this new standard set by the tribunal. So there will be islands here that will have only 12 nautical mile territorial sea, but none that will generate 200 nautical mile EEZ. That will clear up the South China Sea of overlapping exclusive economic zones. Now let's go to the individual features. So we are again here in the Spratlys. You have this is Quarteron Reef. China occupies 7 reefs in the Spratlys. Quarteron Reef, you have Fiery Cross Reef, you have that's Gaven Reef, and then you have Subi Reef, You have Bacchinan Reef, you have Johnson South Reef, and you have Mischief Reef. Now, we raised the status of these geologic features. We admitted that of the 7 reefs that China occupies, 3 are high tide elevations, and the rest are low tide elevations. But we lost on some of these issues, so the tribunal said, of the 7 reefs that China occupies, 5 are high tide elevations, namely Fiery Cross Reef, Johnson South Reef, Gaven Reef, Quarton Reef, and Mackinnon Reef. These reefs are entitled to 12 nautical mile territorial sea. The 2 other reefs, Mischief Reef and Subi Reef, are low tide elevations not entitled to a territorial sea. They form part of the Philippines continental shelf, and only the Philippines can erect structures there, can put up an artificial island, can exploit the resources in these reefs. Therefore, China's structures on these 2 reefs, Subi Reef and Mischief Reef, are illegal. The tribunal upheld the Philippine position on this issue except for Gaven Reef and Mackinnon Reef, because we argued that Gaven Reef and Mackinnon Reef are low tide elevations. We lost on this issue. So the effect is, in the entire EEZ of the Philippines, there is only one Chinese occupied feature that is within the EEZ of the Philippines in the Spratlys area, because Gaven Reef is outside the Philippine EEZ, although it's within our extended continental shelf. So the only feature that has a territorial sea in Mackinnon Reef occupied by China is, in the Spratlys occupied by China, is Mackinnon Reef. Now we go to Scarborough Shoal. The tribunal said that Scarborough Shoal is a high tide elevation entitled to a 12 nautical mile territorial sea, but not to a 200 nautical mile EEZ, since obviously it is not capable of human habitation. The territorial sea of Scarborough Shoal is a traditional fishing ground of Filipino and Chinese fishermen, as well as fishermen from other countries. China cannot prevent Filipino fishermen from fishing in Scarborough Shoal. The tribunal upheld the Philippine position on this issue. Remember, these are maritime disputes. We did not concede sovereignty to China over Scarborough Shoal. We said, whoever owns Scarborough Shoal, whoever has sovereignty over Scarborough Shoal, Filipino fishermen have traditional fishing rights. Because this territorial sea has not been declared exclusive for historic rights, only the exclusive economic zone. So there still remains historic rights over the territorial sea. So we won this argument. So before the ruling, this was the entire disputed area, this red area, disputed by China. Our entire EEZ was disputed by China. After the ruling, there are only 3 features now disputed. Scarborough Shoal, 12 nautical miles around that. Mackinnon Reef, 12 nautical miles around that. Johnson South Reef, 12 nautical miles around that. Because Johnson South Reef, when we filed our claim, we already admitted it is capable, it is a high tide elevation. It's above water at high tide. So this one, we considered this as a rock above water at high tide. This one we disputed, we lost this one. This one we conceded, it's a rock above water at high tide. So if you add up all of that, our total EEZ in the South China Sea is 381 square kilometers. If you deduct the territorial sea of Johnson South Reef, Mackinnon Reef, and Scarborough Shoal, the Philippines will have an EEZ of 376,350 square kilometers in the South China Sea, free from any Chinese claim. This maritime area is larger than the total land area of the Philippines of 300,000 square kilometers. All the living and non-living resources in this maritime area, the fish, oil, gas, and other minerals, belong exclusively to the Philippines. That's the effect of the ruling. we go to the other issue, another major issue, harm to the marine environment. The tribunal said China violated its obligation under UNCLOS to protect and preserve the marine environment when China dredged and built islands on 7 reefs, failed to prevent its fishermen from harvesting endangered species like sea turtles, corals, and giant clams. The tribunal upheld the Philippine position on this issue, and this is a landmark decision because it's the first time that an international tribunal ruled on harm to the coral reef ecosystem. So this is a big win for environmentalists. If you look at Mischief Reef before the reclamation, it's fully submerged at high tide at the start of the reclamation, and as of May 1, 2016, China has reclaimed 590 hectares. That's as big, almost as big as San Juan City. San Juan City is only 594 hectares. And this is how China dredged this. This is the rim of the reef. So this dredger, this is the rotating cutter. It will pulverize the sand here. This is the nozzle that sucks the pulverized corals. And it's sucked here by suction to the ship and forced out by pressure and dumped on the rim of the reef. This is one of the floating pipes that was washed ashore in Zambales. So all the reefs here are dead. All the corals here are dead. The corals here are also dead because they've been, the pulverized coral have been dumped on the rim of the reef. Now, Dr. John McNamara, a world-renowned marine biologist who studied the Spratlys in the 1990s, went back to the Spratlys this year, February of 2016. He surveyed several reefs, including those exploited by clam dredgers from Tanman, Hainan. Dr. McNamara said, the damage was much worse than even I expected it to be. I swam over 1 whole kilometer of reef before I saw a single living invertebrate. It was really massive, massive destruction. Now, he was referring to the reefs that were destroyed by the Tanman fishermen who used the propellers of their fish to pry open the clams from the reefs. The clams attach themselves to the reef, become embedded to the reef, so you have to use something to extract the clams. So they use their propellers. And this is what Dr. McNamara said. The damage was terrible, massive. How compare this to the destruction caused by this? It's even more massive. Another major issue resolved by the tribunal, the unlawful Chinese actions. The tribunal ruled that China violated the exclusive right of the Philippines to its EEZ by interfering with the fishing activities of Filipino fishermen within the Philippine EEZ, interfering with the petroleum activities of Filipino vessels within the Philippine EEZ, failing to prevent Chinese fishermen from fishing within Philippine EEZ, constructing artificial islands and structures, Mischief Reef and Subi Reef, within the Philippine EEZ and continental shelf. The tribunal upheld the Philippine position on these matters. So the tribunal said all these acts of China are unlawful. They violate UNCLOS. They violate the rights of the Philippines under UNCLOS. In 2011, we sent a survey ship to Reed Bank, MV Veritas Voyager, and 2 Coast Guard vessels of China harassed this ship, so they had to leave. It had to leave. In fact, up to now, we could not survey the Reed Bank because Chinese Coast Guard vessels harass our survey ships. Malampaya is here. The 9 dust lines cut through Malampaya. Malampaya is our largest operating gas field in the Philippines. It supplies 40% of the energy requirement of the Philippines, and Malampaya will run out of gas in 10 years. So we really have to develop the Reed Bank. Otherwise, we may have rotating brownouts in the Philippines. Well, we can import, but it will be expensive, import gas. So the tribunal said it was unlawful for the Chinese Coast Guard vessels to harass Philippine survey ships in the Reed Bank. The other issues resolved by the tribunal, the minor issues, the tribunal said China violated its obligation not to aggravate the dispute during the arbitration when China dredged the reefs and built the islands. During the arbitration, China dredged the reefs and built the islands. China destroyed the evidence of the natural condition of the geologic features in the Spratlys. You know, when there is an arbitration going on, international law says that the parties should not do anything to aggravate the situation, should not do anything to make the decision moot and academic. China violated these rules because China, while the arbitration was ongoing, China dredged the reefs, the very reefs that were at issue. China, because it dredged the reef, it actually destroyed the evidence of the natural condition of the geologic features, because we said Mischief Reef is a low tide elevation. But China covered it, and it's now 590 hectares of land above water at high tide. You know, it's a very, very damaging thing to do if the tribunal will say you destroyed evidence needed by the court. And China did it. China also violated its obligation to observe maritime safety when Chinese Coast Guard vessels crossed the path of Philippine fishing vessels at high speed. We complained that our fishing vessels were harassed. The Chinese Coast Guard vessels will cut through our fishing vessels. And the tribunal agreed with us. That's a violation of the obligation of China to maintain maritime safety. Everybody has an obligation to maintain maritime safety at sea. The tribunal refused to rule, however, on two issues. The tribunal refused to rule on the standoff between the Philippine Marines and Chinese Coast Guard vessels in Ayungin Shoal. The tribunal said that this issue involves military activities outside the jurisdiction of the tribunal. So we lost on this issue. The Philippines asked the tribunal to direct China to respect in the future the rights and freedoms of the Philippines under UNCLOS. Well, the tribunal declined to rule on this issue since the tribunal said bad faith is not presumed in the performance of duties under UNCLOS, which already mandates that the parties to the dispute shall comply with the arbitral tribunal award. So the tribunal said, well, we don't rule. But if you look at UNCLOS, it says the parties to the dispute are under obligation to comply with the ruling. So those are the issues. What are the next steps? The next steps will be the enforcement of the ruling. So I divide the ruling into two portions. You have enforcement of the ruling by the world's naval powers with respect to freedom of navigation and overflight for military vessels and aircraft in the high seas of the and EEZs of the South China Sea, and enforcement of the ruling by the Philippines with respect to its exclusive right to exploit the resources of its EEZ in the South China Sea. So the ruling says the 9 dash lines are void. The effect is there are high seas, 25% of the South China Sea high seas, and you have the EEZs of Vietnam, the Philippines, Malaysia, Brunei, Malaysia again, and Indonesia. And under international law, under UNCLOS, the high seas are open to navigation and overflight for military and civilian vessels and aircraft. There's freedom of navigation and overflight for civilian and military vessels and aircraft here. In the EEZ, the same thing. There's the same freedom. Freedom of navigation and overflight for military and civilian vessels and aircraft. Of course, the territorial sea is different. So the world naval powers have declared they will sail in the high seas of the South China Sea. They will fly, assert their freedom of navigation and overflight. They also said, we will sail in the EEZs of the South China Sea, and we will fly over the EEZs of because they will assert their freedom of navigation and overflight for their military vessels and aircraft. So who will enforce the ruling? The world naval powers, because it is in the interest of the world naval powers to assert their freedom of navigation and overflight over the EEZ and high seas. Why? Well, they have very expensive warships and warplanes, if they cannot sail and fly over the EEZs of coastal countries, their warships and warplanes will be bottled up in their coastal waters. So it's a very important thing for naval powers, freedom of navigation and overflight for their military vessels and aircraft. They have to assert that. They cannot afford any coastal state closing the EEZ or the high seas. And the French defense minister during the Shangri-La dialogue last month said, we will sail in the South China Sea, high seas and EEZs. We will fly, and we will ask our European neighbors to join us in our patrols. Well, Australia is flying over the EEZ of all of these countries quietly. India has sailed in the EEZs of the South China Sea. So it is in the interest of all these world naval or regional naval powers to assert freedom of navigation over flight. So that will be complied with. That ruling will be enforced by the naval powers. The other part, of course, well, let me explain further. The high seas start from here, at the edge of the EEZ, and the EEZ start from here. So this one will be enforced by the naval powers, the freedom of navigation and overflight. But in the EEZ here, we have to do it ourselves. We do not expect the world naval powers to enforce the ruling with respect to the exclusive right of the Philippines to exploit its natural resources in the EEZ. That is a task for the Philippines. So how will we do it? Well, if China installs a gas platform in the Reed Bank, what can we do? We don't have the military might to drive away, to remove that gas platform. Well, we can, let's say, Sinuk, China National Offshore Oil Company, will install a gas platform in the Reed Bank. We can sue in Canada, where Sinuk has assets. We will show the Canadian court the ruling of the tribunal. Canadian court, your country is a member of UNCLOS, and UNCLOS tribunal has ruled that the gas in Reed Bank belongs to the Philippines, and Sinuk took it away from us. Sinuk has assets in Canada, seized those assets to compensate us for the loss of the gas. We can do that. So, or we can sue China to recover damages for the severe harm to the marine environment. There's already a ruling by the UNCLOS tribunal. There was severe damage to the coral reef system in the Spratlys. And mischief reef is part of our submerged continental shelf. So it's just a matter of quantifying. We can file a case again in the UNCLOS tribunal, ask the UNCLOS tribunal to quantify the amount. Or, you see, UNCLOS was negotiated as a package deal. This means that if you ratify UNCLOS, you cannot cherry pick or select what provisions you want to comply with, what provisions you reject. You must accept everything, all the UNCLOS provisions, including its dispute settlement mechanism. Now, China has applied for 4 permits with the International Seabed Authority. That's a creation of UNCLOS. That's a permit to explore the resources of the seabed beyond the national jurisdictions. China has the highest number of exploration permits issued by the International Seabed Authority. The authority has issued 27 permits. 4 have gone to China, the highest number for any state. We can ask the International Seabed Authority. China is not taking UNCLOS as a package deal. China is accepting benefits under the seabed provisions, but rejecting the burdensome provisions under the dispute settlement mechanism. And until China complies with the UNCLOS tribunal's ruling, please suspend the exploration permits. We can also ask the UN Commission on the Limits of the Continental Shelf. That's also a creation of UNCLOS. It validates claims for extended continental shelf. China has applied for an extended continental shelf in the East China Sea, so we will ask the UN Commission to suspend the processing of the application of China because it's again cherry picking. China is complying with one provision and not complying with the other provisions. So there are many ways of engaging China in other legal measures to comply with the ruling. Well, the tribunal's ruling settles the maritime dispute, but it does not settle the territorial dispute because the tribunal under UNCLOS has jurisdiction only over maritime issues, maritime disputes. The territorial dispute remains. That's why we said Scarborough Shoal, whoever has sovereignty over it, the tribunal doesn't have to rule, but we have traditional fishing rights there. So the territorial dispute remains, and I don't think that will be resolved in the next 500 years. So my proposal is a win-win solution that the territorial dispute in the Spratlys, with respect to this dispute, all claimant states shall suspend for 100 years their territorial claims and declare all the low tide and high tide features in the Spratlys and an area of 3 nautical miles around its feature as an international marine peace park for the benefit of all coastal states in the South China Sea. This ensures that the Spratlys will remain the South China Sea's nursery where the fish spawn. Now, the eggs and larvae of the fish that spawn in the Spratlys are carried by currents all the way to the coast of China, Vietnam, the Philippines, Malaysia, Brunei, Indonesia, Sulawesi, Celebes Sea. So it's actually the nursery of the South China Sea. Very extensive coral reef system that constitute the nursery of the South China Sea. We all benefit if the Spratlys are maintained as a peace park. So I think it's for the benefit of everybody. In a marine peace park like this, only Coast Guard will be allowed, no military installations. The islands already possessed or artificial islands possessed by any state, they can remain in possession of those islands, but they can use those islands only for marine scientific research and ecotourism. Now, there is a precedent to this. The 1994 peace agreement between Israel and Jordan created the Red Sea Marine Peace Park in the Gulf of Aqaba in the Red Sea. So it's not impossible. It may be difficult, but not impossible. And I think this is a face-saving solution for everybody. Nobody loses, everybody wins. So in the Spratlys, you have all of these islands occupied by many countries. You will enclave them 3 nautical miles around those geologic features, and that they will constitute the Spratlys International Marine Peace Park. This is a proposal of actually the one who proposed this first was Professor John McManus, the world-renowned marine scientist that I mentioned to you. So this is not my original idea. I'm just supporting Dr. McManus in the creation of a peace park in the Spratlys. So with that, I end my brief presentation. Thank you for your kind attention.
Thank you very much, Justice Carpio, for the enlightening and in-depth lecture on the recent decision on the Permanent Court of Arbitration in The Hague. So we now move on to the next item on our program this afternoon, which is the panel discussion and open forum. May we call on the panelists to occupy the chairs on stage. We have Justice Carpio, Father Aquino, the Dean of San Beda College of Law, Graduate School of Law, Assistant Secretary Roy de Vera Turda of the Department of National Defense, Captain Rodrigo Mejia, and Attorney Toby Purisima.
So as we are waiting for our panelists to settle down at the stage, we would like to open. Hello. We would like to open the floor now for any questions or reactions that you would like to address to our panelists. Would anyone want to ask the first question from the floor?
You may approach the mics on the left and the right side of...
There's a mic there, sir. As you approach the microphone, kindly state your name, designation, and your affiliation, sir.
Yes. I'm Tong Payumo, former congressman and Subic Bay chairman administrator. May I ask Justice Carpio, because I'm from Bataan, and the fisher folks, not only from Masinloc, but of all the coastal towns of Zambales and even Bataan that depend on Baja de Masinloc or Scarborough Shoal. Their problem is immediate, and the marine park is all good, but the terrain and the arid lands of Zambales cannot support the livelihood of the people in Zambales, unlike central Luzon. They depend on fishing, and there's only a narrow strip of flat land on the western coast of Zambales. They are prevented from going to fish in Scarborough Shoal. What can they do now in the light of all these, with the award of the arbitral tribunal? Can they go back there and risk their lives? Thank you.
Thank you. Thank you, Congressman Payumo. The ruling says that whoever owns Scarborough Shoal, the shoal is a traditional fishing ground of Filipino and Chinese fishermen and other fishermen from other countries. So it's a common fishing ground, which means that China and the Philippines at least must come out with ground rules to fish there, because the fishing has to be sustainable. We cannot allow overfishing, because that will just be a very brief respite for our fishermen. So the allowable catch for each country must be set. We must set protocols so that there will be no fighting among the fishermen. So in other words, we have to sit down with China to operationalize the common fishing ground. Now, I've always said that in the meantime that our fishermen cannot go to Scarborough Shoal. Let's say it takes them 1 day to fill up their banca if they go to Scarborough Shoal. But if they go to other areas, it will take them 3 days to fill up their banca. So the government should subsidize the gas of the fishermen in the meantime, so that at least they will not fish at a loss. That's just a temporary arrangement until we settle this issue of common fishing ground with China. So I hope that our government will extend financial assistance to our fishermen in the meantime that they cannot go to Scarborough Shoal. Give them money, they will not be fishing at loss. So that's my answer to your question, Congressman.
Hello? So, does anyone else have a question? Sir.
Good afternoon, Justice Carpio. I'm Renato De Castro from De La Salle University. I'm an academic. You mentioned, of course, about the importance of bilateral negotiation with China, and of course, that has also been mentioned by the government in the light of the legal victory we were able to achieve. But the impasse right now is the fact that China, the condition of China before any bilateral negotiation would start is that the Philippine government should disavow or ignore the award that we got from the tribunal. So how do you proceed? I think basically, and of course you have a threat from no less than from the foreign minister when Foreign Minister Wang Yi talked with our foreign secretary on the side in Mongolia that if we do not accept China's condition, this might be another ground for a confrontation. So how do you proceed this impasse, and is there a way that we could hopefully circumvent this? I would see a pending impasse between the Philippines and China in the light of the award that we just achieved.
Thank you for that. Well, I would break the negotiation with China into two phases. The first phase is to reopen the talks without preconditions. We just sit down with them and agree how do we proceed. We will not bring up the ruling. They will not bring up their 9 dash lines. So we just talk how to go forward. But in the formal negotiations, we have no choice. We have to bring up the ruling because our negotiators cannot negotiate outside of that because of constitutional constraints. Because under the Constitution, the EEZ exclusive because the exploitation of that economic zone is exclusive to the coastal state. That's given to us by international law. It's the exploitation is exclusive to the Philippines. So why do we share it? Second, our Constitution says that the use and enjoyment of the exclusive economic zone shall be reserved exclusively to Filipino citizens. So if it is a disputed area, yes, we can share. But if it's no longer disputed because there's a ruling of the tribunal, it falls under our EEZ. So I think, I think China will agree to talk about the common fishing ground. And we can talk without preconditions on how to proceed. Thank you.
Any more questions? Yes, sir. The one in the blue shirt.
Magandang hapon sa lahat. Ako si Mr. Salvador Franz ng Pamalakaya, Pilipinas. Kami po yung mga mangingisda, ano? Bali, ang tanong ko lang dito, doon sa binabanggit kanina, 100 taon yung magiging marine sanctuary, ang ating 200 economic zone. Na bahagi ng mga bansa ay susunod sa ganitong proposal. Ang tanong kasi ngayon kami ang direkta dati na nangingisda doon sa inaagaw ngayon ng China. So, kung ganong kalawig yung pagiging marine sanctuary at ang aming kagamitan sa pangingisda ay halos kupong-kupong 16 horsepower ang aming bangka, na kami ang kumikita sana sa isang linggo dyan na mga 5,000 na mga mangisda. Ngayon, dahil sa high-tech na kagamitan ng mga bansang kaagaw ng Pilipinas, lalo-lalo na ang China, na hindi sumusunod sa mga polisiya, so mariin lamang na magugutom talaga ang mangisdang Pilipino. At tandaan natin lahat, 5 milyon toneladang isda sa loob ng isang taon ang kinukuha dyan ng mga mangisdang Pilipino, at yan ang kinakain ng mamamayan dito din sa Metro Manila. So kung ganon, 20% ng isda natin ay galing dyan. Kung hindi tayo makapangisda dyan, sigurado ko po, mag-aangkat tayo ng isda ng galing Japan, galing China at ibang mga bansa, na dito dadalhin sa atin yung hinuli mismo na isda dito sa Scarborough Shoal. So ang problema namin ngayon, walang direkta na tugon ang gobyerno doon sa kahirapan namin kinakaharap. So ibig sabihin, Kung mayroon man na ibibigay sa amin noon, 2014, 2 kilong bigas at saka sardinas. Pero ngayon talagang wala na. Direkta kami nawalan at nawalang pangisdaan. Kaya ang demanda namin ngayon, bukod doon sa mga ganitong purong baylat ng gobyernong Duterte, ano talaga ang magagawa ng sambayanan para doon na makuha natin uli yung inaagaw sa atin na malinaw na ito talaga ay atin. Yun lang po, maraming salamat.
Malaman po lang namin kung kanino po ninyo gustong to all of the panels. Okay, so the reactor, the question would like to be, and Justice Carpio would like to respond.
First of all, we are not, the Marine Peace Park will not cover Scarborough Shoal. The Marine Peace Park will cover only islands actually occupied now by China, the Philippines, Vietnam, and Malaysia, and 3 nautical miles around these islands that they occupy now. Right now, you cannot go there because it's occupied by other countries. So what we're saying is no military facilities in these features already occupied in the Spratlys. We will turn them into a nursery for the fish. But it's only those features and the 3 nautical miles around. So there's a vast area that's free. We're not covering Scarborough Shoal because that's a traditional fishing ground. And Scarborough Shoal has not yet been dredged. The other areas have been dredged already. So we're trying to, well, if ever, to get it, to get the corals there to regrow. It will take time. Some of those corals are dead forever. So your fear that we're talking about the entire EEZ as a marine park, no, of course not. It's only in the Spratlys and only on islands occupied by countries now and their territorial, not even their territorial, just 3 nautical miles. So now, on your other concerns, well, I've already said that the government should provide assistance in the meantime that you cannot go back to Scarborough Shoal.
Any other reactions from our panelists?
I fully understand the frustration of our fisher folk who are unable, despite the victory of the Philippines, to go back to their fishing grounds because they're prevented. Although I do think also that going off to sea to the Scarborough Shoal 1 day after the judgment came out was rather precipitous. We should have given time for things to settle and simmer down. But I reiterate the position of Mr. Justice Carpio. In regard to the EEZ, no other sovereignty will assert our rights other than the Philippines. So I wish that the Philippines would be more resolute in regard to its claims in the light of the judgment of the EEZ, because if we appear to the international community even to be apologetic of the fact that we won, I don't know how other countries are going to stand up to support our claims. It looks like we are even sorry that we won, but if we are resolute about the fact that the court has adjudged in our favor, let's ask for the enforcement of our rights under the exclusive economic zone. Exactly how we will do that, I don't have the answer. That's a diplomatic and that's a strategic answer, but let's start with that. And I do support the proposition, dialogue can take place in respect to those matters that have not been adjudicated in our favor. One thing I find very interesting about this judgment, for me a first in international law is there are effects on territorial claims without the court having to rule on territory. The court knew very well it had no jurisdiction to rule on territory. It ruled on that in the first phase of the judgment, the jurisdiction phase. Nevertheless, many of its pronouncements, for example, that reclamation, construction of installations was in violation of international law, has territorial effects without any direct ruling on sovereignty over territory. And that for me is a very interesting feature of the judgment.
Any other comments from our panelists? Asek de Veraturda, would you want to respond to that, sir?
personally ako ay kasama mo rin na nagdaramdam dun sa sinasapit ng ating mga mangingisda na sa halip na atin yung karapatan na mangisda sa ating 200-mile exclusive economic zone ay hindi natin magawa. Sa point of view ng isang kawal at ngayon ay gumagawa ng policy sa ating tanggulang pambansa, ay ang magagawa rin namin ay kung hindi naaatasan upang ma-perform ang kung anumang iaatas upang kayo maprotektahan, ay hindi rin po namin yun magagawa. Subalit kung sakaling dumating ang panahon na kinakailangan ng isang bagay na manggagaling sa tanggulang pambansa upang ating maprotektahan ang ating mga mangingisda at kanila talagang ma-exploit kung ano man ang nasa exclusive economic zone, ay marahil ay tatalima ang tanggulang pambansa tungkol riyan. Sapagkat isa sa mga tungkulin natin ay yung pangalagaan ang ating national interest sa exclusive economic zone. So, sa kasalukuyan ay pinipilit nating magkaroon ng mas malakas na kapabilidad upang kung sakali at kung wag naman sana nang dumating ang oras na kailangan ba ng pag-agapay ng ating Department of Defense, ay magawa namin yon. Ang gusto ko lamang ipaharating dito, ang policy pa rin ay, of course, resolve this issue by peaceful means. And of course, I'd like to tell you rin, ating mga mangingisda, that I would always take the view that nobody knows the meaning of peace more than the men and women in uniform ng ating Armed Forces of the Philippines and the Defense Department. But again, I'd like to ulitin ko ulit na kung sakasakali man na darating ang panahon na ganun nga, huwag po kayo mag-alala, mga kababayan kung mangingisda, at gagawin namin ang nararapat kung sakali mang dumating ang panahon na yon.
Thank you very much, Asec de Veraturda. Okay, we have another question. Please state your name and your affiliation, please.
Yeah, I'm Ellen Tordesillas. I'm a journalist. I'd like to direct my question to Justice Carpio. What's the effect of the arbitral tribunal's ruling on the contract awarded by the Department of Energy to Mr. Pangilinan's Forum Energy to explore Reed Bank? Can they now proceed with that?
Well, technically, yes, because the Reed Bank is free from any overlapping claims. We have a full EEZ in the Spratly side, in Palawan side, except for Makinan Reef and Johnson South Reef, the 12 nautical mile area around those two features. Everything else is free as far as China and the Philippines are concerned. So technically, we can proceed already to the Reed Bank. But of course, it would be more prudent to sit down first and tell China that there is this ruling, and we will have to exercise all our rights now.
Are there any other questions? Sir.
Sir, good afternoon, Sir. Commander Rosario, Inocencio Rosario from Philippine Coast Guard, sir. Sir, as I understand, sir, the International Tribunal judged that the Scarborough Shoal is a common fishing ground, sir. But my question is, how about the natural resources that it is invaded there, sir? Since I heard that there's also a huge natural gas in Scarborough Shoal, sir. Since it is under the AAC, do we have the rights to explore the natural resources in there, sir? Thank you.
Well, Scarborough Shoal is land, it is territory. So it is governed by territorial provisions of international law. Only the UNCLOS can decide the maritime entitlement only, whether it's 12 or 200 nautical miles. Since it's a territorial issue, the shoal itself and 12 nautical miles around that, that's territory and territorial sea. That dispute has not been resolved. We have to submit that to arbitration, but of course China has to agree, and I don't think China will agree. So that has not been resolved. What has been resolved are fishing rights, because under UNCLOS, the historic rights in the territorial sea were not extinguished by UNCLOS. It remains. Only the historic rights on the EEZ have been extinguished. So that remains in dispute. Scarborough Shoal and its territorial sea as a territory remains in dispute.
All right. Yes, ma'am.
I'm Araceli Lorayes. I'm a freelance writer. I'm directing the question to Justice Carpio. You said that China at present has a lot of permits pending with a subsidiary judicial body of the UNCLOS based in Canada. Now, if we go from past behavior and assume that it's predictive of future behavior, if the permits are not granted, they will continue to do as they please. Now, if the Philippines were to file a case, maybe on behalf of fishermen whose rights have been violated, and wins the case, can the Philippine government get damages? And what is the jurisdiction of this subsidiary court? Can it, for example, seize assets of China in in the United States? Because I understand that the Chinese government holds a substantial amount of, for one thing, US debt paper.
Thank you for that. Under international law, a state that violates international law will be liable for its violation. That's the general rule. So yes, for the damage to the environment, we can sue for damages. We can bring it to an UNCLOS tribunal for preventing our fishermen from fishing in our EEZ or in our traditional fishing rights, traditional fishing areas. Then we can also sue before an UNCLOS tribunal and ask for damages. So, but we are not yet there because we just got the ruling. We'll sit down first and find out if China is willing to at least those provisions.
Yes, sir.
You may use this mic, sir. I'm Major General Molina, sir. I'm the J5. And I'd like to direct this question to Justice Carpio, sir. At all sides, from all directions, even including from the internal arena or dimension, it would seem that China is vulnerable to escalating misunderstandings, increasing instabilities, and potential conflict. Along its 4,000-mile border to the west. Mongolia, 3 Central Asian states exert irregular pressures through Xinjiang and Tibet and Inner Mongolia. Of course, ringing around China with Japan to its west. We have Vietnam on the southwest is India and Russia on the east. And all other, about 20 contiguous states. We have, of course, the Great Lake that they call it. They're also increasingly putting pressure on China. That would qualify, in a sense, China to be one big island. So that's taking it from the geostrategic perspective. Now, from this recent recent ruling, it would appear that China is even more isolated. When we take into consideration all countries around the world who had signed on to UNCLOS. And that's from the international legal position. But from the real perspective, from real world politics, we know that China is an overextended entity. It's not only a country, it's a civilization state whose preponderant presence are manifest around us, west of the Philippines, right there in the South China Sea. Hostaging Reed Bank, confronting our troops off Ayungin Shoal, building their artificial islands at Fiery Cross, now planning to, in fact, do tours, the great China Dream Tour around the South China Sea. So, sir, how do you foresee the enforcement by the naval powers? How would this actually help in the freedom of navigation operations and overflight? Where would this lead? Would this lead to more tensions and even open conflict in the region, given the fact that they're already there and they're real, their forces are there, and we also have the United States, Japan, and Taiwan are all militarizing the area and changing the entire calculus. And on our side, on the Philippine side, we dismally lack the capabilities.
Thank you for that. The dispute between China and the US and other naval powers is very simple. The naval powers led by the US assert that in the EEZ of a coastal state, there is freedom of navigation and overflight for military vessels and aircraft of other countries. China holds the opposite position, that in the EEZ of a coastal state, foreign warships and warplanes must secure permission first from the coastal state before sailing and flying. Now, if you look at the reason behind this position of naval powers, is that if they don't have freedom of navigation and overflight in the EEZs of other countries, then their expensive warships and warplanes will have to stay in their coastal waters. If you go to the Mediterranean Sea, there are no high seas there, only over exclusive economic zones. So if the US Navy will have to ask permission from each coastal state to sail in the EEZs of the Mediterranean Sea, they may not be able to enter. That's why it's in the national interest of every naval power to assert freedom of navigation and overflight in the EEZs of other countries. China is, I consider China now a naval power. China is about to become a world naval power. In 2015, China conducted naval drills with Russia in the Mediterranean. There are no high seas in the Mediterranean, only EEZs. China sent its warships there, conducted drills, and never secured the permission of any coastal state, contrary to their position. In 2015, China sent a warship, surveillance ship, to the EEZ of Hawaii without seeking permission from the US. Also last year, China sent a naval task force to the US Aleutians of Alaska and never secured the permission of the US when it sailed through the EEZ of the US. Earlier, China sent a warship through the EEZ of Guam, never secured the permission of the US. So China, I think, in the next 5 to 7 years will change its position because it is now a world naval power. If it does not change its position, its warships and warplanes will be bottled up in the coastal waters of China. So that dispute on freedom of navigation or flight will be settled because it will now be the common national interest of China and the US naval powers that there should be freedom of navigation and overflight in the EEZs for warships and warplanes. That will leave us with our own dispute with China over our natural resources in our EEZ. That's why I said right now there's a convergence of interest between the Philippines and US and other naval powers, but up to a certain point only. We will have to think of how we will enforce our rights over our own EEZ, because the naval powers will not help us there. Thank you.
Yes, ma'am.
Hi, good afternoon. I'm Isay Reyes from GMA7. Justice Carpio, I'd like to address the question to you. Our reporters have been experiencing, they've been doing expeditions in the Scarborough Shoal after the decision of the tribunal, but then they have been seemingly harassed with the fishermen by the Chinese Coast Guards, wherein they were being rung by sirens, and then they were asked to go as far as 7 nautical miles, and then they were being escorted out. Sir, what would you advise our fishermen to do, or even those who are trying to sort of like establish our right after the ruling? Should we be doing that, or are we just triggering something that China would most unlikely do or would likely do, which is to react in a violent way?
Well, the tribunal said that the Scarborough Shoal is a common fishing ground. So if it's property for common use, you must have ground rules how to use it.
Mm-hmm.
Because if there are no ground rules, there will be problem. You'll fight over it. So I think we have to sit down with China first, establish the ground rules, establish the allowable catch for each country, so there will be no overfishing. So I think it's premature to send our fishermen there yet. Our government has to sit down to discuss the ground rules on common fishing in Scarborough Shoal.
So, sir, at present, you or the government is advising our fishermen to stop fishing in Scarborough first until such a time wherein we can discuss with the Chinese government.
I don't know what is the advice of the government. My views are not the views of the government, but I'm saying that because the tribunal said common use, so we have to establish the ground rules for common use. We have to do that first.
Sir, but for your insight, what could you say about the treatment of the Chinese Coast Guard? I mean, even after the decision of the tribunal, they are still being very assertive, or?
Well, you see, you have to look at the mindset of the Chinese people.
Mm-hmm.
From grade school to college, they were taught that the South China Sea, the waters of the South China Sea belong to them since 2,000 years ago. Of course, the tribunal said that's not true, that's false. But it's in their mindset. In fact, in their examinations, they are asked, what is the southernmost territory of China? James Shoal, that's in EEZ of Malaysia, 950 nautical miles from Hainan. It's in their DNA. When we sit down with them, with their diplomats, and we tell them that that is our EEZ, they said, no, it's ours. There's nothing to discuss. That belongs to China. It's our indisputable territory. It's in their DNA. When Foreign Minister Wang Yi spoke before the CSIS last February, he said that the Philippines and China are neighbors just separated by a narrow body of water because they are counting from the 9-dash line. So from the 9-dash line to our shore, it's a narrow body of water. So we are trying to change this mindset, and that will not change overnight. We start with the ruling. We have the ruling. And we need the support of the world community, of the other countries in the world to help us convince China that it is to their national interest, in their long-term national interest, to abide with the ruling. So, as I said, China will not just roll over the next day after the ruling and give up. This is an intergenerational struggle, and we have to persevere here. Thank you.
Sir, is there a timeline that you are looking into? For example, if you can have a dialogue with the people that are supposed to be sitting down with the Chinese government, if we could do it, or would you suggest that if we do it as soon as possible so that the welfare of the fishermen there could be secured?
Yeah, my suggestion, it's my suggestion, personal suggestion. We should first talk to consult with our ASEAN neighbors, Vietnam, Malaysia, Brunei, and Indonesia, whose EEZs are also encroached. That, with this ruling, we plan to talk to China. Because it will be a bilateral talk, and we said it will be a multilateral solution that was before. But with this, we can go bilateral now. But we have to consult with ASEAN friends first. And we also consult with the US and our other allies and friends because they've been very supportive. And we'll tell them that we'll use the ruling to discuss things with China. So we have to consult with our friends before we sit down. Thank you.
Sir, sorry, my second to the last question. So do you think, sir, the Filipinos are supposed to lie low a bit? So that, are the fishermen supposed to lie low a bit so that we would not trigger any untoward incident?
Again, please.
Justice, my question is, do you think that the Filipino fishermen should lie low a bit? They should not cross that area first?
Outside of the territorial sea of Scarborough, we can fish. But within the shoal, I think we should wait for the ground rules. We'll have to sit down. Because it's like a condominium. We have to sit down with the other users so that there will be no fighting.
And Justice, my last question would be, at the moment, do you see any grounds for the Philippines to sue China for the things that they are doing right now? Even if ma'am here earlier asked about the violation, if ever that's futuristic though, but at present, after the ruling, are there any grounds that we have to be able to sue China?
Yes, we have a very strong grounds because the tribunal already ruled that China severely harmed the marine ecosystem in the Spratlys. So we can bring a suit to quantify the damages, no longer to determine whether there was harm or not, because that has been established already. But we have to sequence this. I mean, let's talk first.
All right. Thank you, Justice.
May I just go back to the previous question? I think he did raise a very important point, which is that China itself is making many claims under international law. The Tibet question, probably its claims even over Taiwan as a breakaway province, its excursions into the Aleutian Islands. So on that basis, I don't think China can really ride roughshod over international law and say we don't really care about the judgment of the tribunal. It does care because many of its claims are staked on international law. But we have to distinguish between the sphere of rhetoric and what it will actually do. In the area of rhetoric, it will appear to be tough talking. It will say we don't recognize because it has to placate its own people. But on the other hand, we are in a better world when everybody, the Chinese included, accept the fact that there is such a thing as international law. So I'm very grateful to you for having pointed out that China does have many international claims too that rely on international law. And as for the claims that we may raise against China on the basis of having destroyed our marine resources, the key international law doctrine, of course, is the doctrine of state responsibility. But that will have to be worked out at some later stage, as the good justice here, I think, says rightly. Let's sequence the events. Let's get talking first, lay ground rules. But at the same time, let's be assertive about what has been ruled to be ours under international law.
30 seconds. I'd like to add to the discussion so that this problem will not go away in the near term. I would always take the view that we just have to have strategic patience and really come up with a good strategic objectives, and of course all anchored on the ruling of the tribunal. And I'd like to perhaps add that we really have to do a lot of calculations in trying to solve the issues in the West Philippine Sea or the South China Sea. And again, I'd like to stress that this will not go away on the near term, and this will be with us in perhaps in the long term, and a correct calculation will be best for everybody, and including, of course, China, not only the Philippines.
Thank you, Asek.
Yeah, I'd just like to point out two things. As we hear the discussions, I think two things are evolving here now. With this win, we need first internally a whole of government approach. We need to discuss what we have won with this, what we need to do to enforce this ruling. So that's internal, the whole of government approach on the part of the Philippines. Secondly, what we need externally, internationally, is a whole of world approach because everyone else is interested to enforce this ruling. That is very true, because this is a very expansive ruling and this is a very crucial ruling. And therefore, the nations of the world will need to understand this and will need to enforce this, as the good justice lectured earlier. So those two issues will be very important as we continue to understand this, as we continue to discuss, and as we continue to work together. A whole of government approach on the part of the Philippines and a whole of world approach on the part of our regional allies or even sub-regional allies, and of course globally.
Okay. This question is addressed to the entire panel. My name is Tomas Falconiti. I'm a former member of the OSS AFP, and currently I'm a paralegal in RSD Law Offices and fourth-year law student of De La Salle University. My question here is, first of all, the way I see it, this decision, and I think everyone will agree, this decision is a victory to the entire ASEAN community in as much as it is a victory to the Philippines, because a lot of the countries involved here are ASEAN states. Perhaps I also share the view of Dr. De Castro in as much as our hesitation in going to bilateral talks with China, because one of their preconditions, as mentioned, is to disregard the ruling entirely. So my question here is, what is the harm in approaching this in a multilateral scale, not just in a bilateral talk? Because as was mentioned by Justice Carpio earlier, this is a bilateral talk with a multilateral solution. What is the harm when we approach it multilaterally at the start? We engage with the ASEAN states, create a code of conduct or whatnot. Because the way I've been, if I can see it if I can process it properly, it's still going to be bilateral talks with China. But everyone here is involved. So what is the harm if we start in multilaterally at the offset and create a code of conduct? I mean, because it's kind of estoppel in their part. They participated in the proceedings and now they're questioning the judgment. So it would have seemed that it would be for naught if we disregard this ruling just for the cost of sitting in a table one-on-one with China. So I address this question to the entire panel.
May we know who wants to answer that first, sirs?
Okay, I'll answer that question. Since we work together at OSS, well, if we go to multilateral, well, we have to talk with our ASEAN neighbors. That's also good. But we should also, because right now we are in a complex situation. There are a lot of ambiguities. We have a benign situation right now. So it's very, I would say that we open our talks multilateral with our ASEAN states. At the same time, we could also open our talks with the Chinese. That's based on bilateral. So that's a win-win situation, multilateral, at the same time bilateral. At the moment, we should open our talks with China. as discussed by Justice Carpio, we have to read the strategic mindset of the Chinese. Because right now, they were hurt by this decision made by the PCA. So that's normal. So let's be patient. Let's open our child talk with the Chinese. At the same time, talks with Multilateral, talks with the ASEAN, Japan, Australia, our traditional ally, the US, and see how it goes. But I mind you, this conflict will not go away for the next 2 years. As long as the Chinese would not impede the ceilings of communication or block the freedom of navigation, then there will be no problem in that case. But the moment the Chinese block the ceilings of communication and the freedom of navigation, that's the real problem. I don't think the US, Australia, Japan, or Taiwan would be happy for that, because you have to remember that every day there are millions of barrels of oils and liquefied gas passes through the Spratly Island. That's the South China Sea. So that's important to remember. So at the moment, in the Philippines, we should strengthen our defense cooperation with our allies, at the same time strengthen our defense capability.
Next question.
Peter Wallace, business sector. The Chinese say that this issue is indisputable. I suggest the Chinese read an English dictionary. This is very disputable, and we are disputing it. The Chinese have threatened to create an ADIS over the airspace in South China Sea. If they do, and it's certainly very possible the way they are reacting so far, does this cover commercial aircraft or only military aircraft? If it does commercial aircraft, what should PAL and other airlines do? My suggestion is they should ignore it. I can't imagine China shooting a commercial plane out of the sky, but I'd be interested to hear what the Justice Secretary says.
Yes, the ADIS normally covers only civilian aircraft, because military aircraft will not comply with an ADIS of another country. And the normal procedure is the civilian aircraft will identify itself if it is on a path that will bring it inside the territorial airspace of the country imposing the ADIS. That's one. Before China imposed its ADIS in the East Sea, that rule was uniform among all countries that impose ADIS. Only if your flight is towards the territory of the country that has imposed the ADIS, you have to identify your aircraft, civilian aircraft. The other rule is you cannot put an ADIS over disputed area. Before China imposes ADIS in the East China Sea, no country has imposed an ADIS over a disputed area, because that's offensive. That's an unfriendly act if you impose an ADIS over a disputed area.
But didn't China?
But China did it.
They did it up in Japan.
Yes, broke the two rules. China is the only country that has imposed an ADIS over a disputed area and has required even civilian aircraft passing through parallel, not going into the territory of China, requiring all these aircraft to identify itself. So that's the problem of China's ADIS. It does not comply with the rules, common rules adopted by other countries.
So what should we do if they do?
Well, as usual, the Americans, the Japanese will not comply as far as their military aircraft are concerned. But the civilian aircrafts might, just like in the East China Sea, although I understand that Japanese civilian aircrafts do not comply. So some countries will comply, others will not, but for military aircraft, they will not comply.
But should we not comply, given our strong position on the East China Sea and our rights to it, and UNCLOS's agreement with us? Shouldn't we just refuse to declare that we are traveling through that space and leave it to China to take whatever action it might?
Well, for our military aircraft, of course, they will not comply. But for civilian, that will have to be a decision by our Civil Aeronautic Administration, because they're concerned with safety. But there is already an FIR, Flight Information Region, where all air traffic is monitored by a certain country that's been designated by the ICAO. That should be enough. But China has imposed another layer. But the ADs that China imposed in the East China Sea is not being followed by military aircraft.
Okay. Any other comments from our panelists? No? Yes, we go to the next question then.
Sir, I'm Lieutenant Commander Saidi Pakulba from the Office of Naval Strategic Studies. Any member of the panel can answer my question. My question is, as the arbitration results are favorable to us, and we can legitimately enforce effective administration of our islands in Kalayaan, will the government now allow improvement of the islands we occupy, such as the improvement of airstrip and development of ports and facilities in the Kalayaan Island to sustain the local population there?
There's no adjudication as to sovereignty over islands. The tribunal was very fastidious in confining itself to sovereign rights. In fact, the Philippine government itself was asked many times prior to filing the case, what are you really, what is your lis mota, really sovereignty or sovereign rights? And eventually we said sovereign rights to be able to invoke the jurisdiction of the Permanent Court of Arbitration. So, as Justice Carpio said, we'll have to go somewhere else again to litigate our sovereign rights over the islands that we claim.
Thank you, sir.
I'm Alfred Armada from Lourdes School of Quezon City. An article dated last 23rd of May from GMANewsNetwork.com has said that President Duterte asked permission from the Chinese government to fish in our own territorial waters, namely Scarborough Shoal, Panatag Shoal, and Bajo de Masinloc. What does this imply about the administration's stand on said case? Thank you.
Well, I think, was that report after the tribunal ruling or before?
It was before.
Well, that was our position when we argued before the tribunal. In our pleadings, we said we have a right, traditional right to fish in Scarborough Shoal. He probably was just reiterating that.
Yes, sir. Thank you.
And then too, let's be careful about delineations. No? Scarborough, that's not territorial sea anymore. 12 nautical miles lang yung territorial sea mo. And then after that, another 12 nautical miles of contiguous zone. And then from the end of your territorial sea to 200 nautical miles, easy na yun. So hindi territorial sea na yung Scarborough.
I'm former Undersecretary Abe Puruganan from the Office of the President for Regional Concern. My question is, China has threatened, this is a similar question on the no-fly zone. China has threatened to declare a no-fly zone in that area. I've seen the air traffic there. It will be very hard for China to impose, even in the civilian airlines. But if China insists to declare a no-fly zone in that area, what would the other countries, especially the countries that use these lanes or these overflights, would it tantamount to declaring war to other countries?
You're through with your question. Yes, actually the ADIS does not, it's not a no-fly zone. You can fly, but you just identify your aircraft to the other country. You continue to fly, provided you identify your aircraft. The purpose of an ADIS is that because planes fly very fast from the edge of the territorial sea, it will take just a few minutes to cross that to the territorial, to the land. So they created an ADIS so that they can be warned of incoming planes that fly to their territory. So the path of the plane must be towards the territory, and the requirement is you just identify yourself. If you're passing through, you're not going into the territory, but passing through. Other countries in their ADIS rules, they don't require identification, but China requires identification.
Good afternoon, sir. I am Norbert Paranga from University of the Philippines, Diliman. My question is, with the Philippines winning this case against China and the pressure from the international community, would soft power could finally trump over hard power?
That's a good question, because some writers recently have said that the U.S. defied the International Court of Justice in the Nicaragua versus U.S. case, that Russia defied the ITLOS, International Tribunal for the Law of the Sea, in the Arctic Sunrise case, and that UK defied the ICJ in the UK, in the Mauritius versus UK case. That's not correct. In the Nicaragua versus US case, the US said, we will not comply, we will not pay damages for about 5 years. But at the end of 5 years, when Victoria Chamorro became president of Nicaragua, she defeated the Sandinista candidate, the US offered her $500 million in economic aid, provided she will withdraw the pending case in the ICJ demanding damages from the US for mining the harbors of Nicaragua. And she agreed. So she asked her parliament to repeal the law requiring the US to pay the damages. And after that, the US gave economic aid of $500 million in her first 2 years. So there was compliance in the end that was satisfactory to Nicaragua in that case. Although the US initially said we will not comply. And if you look at it, they did not comply in a strict sense, paid in accordance with the ruling of the court, but they compensated Nicaragua in some other way that satisfied Nicaragua. That is still considered compliance. In the other case, Arctic Sunrise case, Netherlands sued Russia for arresting the crew of Arctic Sunrise and taking the ship. And Russia refused to attend the hearings. Russia said the ITLOS has no jurisdiction. We will not comply. ITLOS said we have jurisdiction, and Russia returned the crew and the vessel to Netherlands. Russia said we will not comply, but within 1 year, Putin pardoned the crew and released the vessel. So, but Putin said we are not complying with the ruling, we are complying with our own law. But there was compliance in the end, satisfactory to Netherlands. We consider that compliance because Greenpeace made a furor out of it. I mean, it was a headache that Russia didn't need. In the case of Mauritius versus UK, the tribunal said UK violated UNCLOS by creating a marine protected area in the Chagos archipelago without the consent of Mauritius. Someone wrote that UK defied. No, UK accepted the ruling because the only violation was it failed to consult. So UK will just consult again and impose again the marine protected area. It didn't cost them anything. There was compliance. UK never said we will not comply. So, I mean, you have to look at it carefully. There was over 95% of decisions of the ICJ and international tribunals are eventually complied with. The losing party will say we will not comply. We will withdraw. But in the end, they comply, an overwhelming majority, especially if there is world pressure. Thank you.
I'm Tom Rentar from the University of the Philippines. This is a question for any one of the panelists. Well, you just said that eventually you think China will comply, but do you still think there is a possibility that this dispute will escalate to economic issues such as cutting economic relations with China?
Well, when we filed, before we filed the case, we looked at our economic relations with China, and we had more investments in China than China has investments in the Philippines. We buy more from China than China buys from us. And our foreign exchange earnings do not come from China. They come from the Middle East, from the US, from our overseas workers. So I don't think economic sanctions by China will work. And I don't think China will do it. Thank you.
Any questions from this side of the room? Yes, Lugan.
My question is for the Undersecretary of the DND. I just want to know if the Duterte administration has planned to continue the defense capability plan from the former Aquino administration. I read the paper of Dr. De Castro that under that defense capability plan, there will be about 400 billion pesos that will be allocated to strengthen our armed forces of the Philippines. And no less than Senator Enriles said that we have to at least have an offensive plan. So we have to build our military. Will that continue? Or?
That's a very good question. And I'd like to announce to everybody that there's no major policy change in trying to pursue in the long term capabilities that should really be required of any sovereign nation. So the policy is still there.
And my other question is for Justice Carpio. Because of the ruling, how do Filipinos find nationalism? Because the Chinese, they are extreme nationalists. So now that we have won the arbitration, how can we inspire the youth, the Filipino people, that we are in the right direction? Because it's hard to convince the world, the international community, if we ourselves in this room are not on the same page. Thank you.
Well, the DFA, Department of Foreign Affairs, conducted a survey, and I think over 90% of Filipinos support the arbitration. And the DFA has been going all around the country explaining our arbitration case, and I have done my lectures also. So I think slowly our people have understood the issues in this arbitration case. With our ruling, then I think they understand it now more fully, that we have taken the right path. We never wavered despite all the doubts by other people. But I think now it's time to unite, because we have to unite to convince the world to support us in convincing China to comply with the ruling. You know, it's difficult if our own people will doubt the ruling. It's already in our favor. Why do we say that it has done us more harm than good? I mean, probably were they wishing that we would have lost? Did they want us to lose the case? I think we should all unite behind the ruling and convince the world to support us.
Thank you.
If I may add to that, I was once asked by, I think, an Australian friend, what unites you as a people? And I answered, when Pacquiao fights. But what I mean here is, if there is a very important event of national significance, and it's been proven in the past, every time there is a situation like that, Filipino unites. And I have no doubt that this particular issue, all the Filipino people is into this, and we are united in this thing. So don't worry, we're united in this particular issue.
Yes, sir. Jesse Pascasio, sir, from the National Coast Watch Council. Verily, I think what the last few comments that has been made should actually prompt us to rethink whether what is the full effect of the decision should be into our general public. Because I think these kinds of decision, for example, of the PCA, must open up the idea of the nation being really an archipelagic and maritime country. So, for example, how do we convince people, for example, that fish in Scarborough Shoal is that big issue that needs full attention of the public, when we in fact we measure our food security from rice rather than on the need for fish, because 28.5 an average Filipino would eat 28.5 kilograms of fish per year. So if you total it up with our general population, we need 2.8 billion kilos of fish yearly just to feed our growing population. So I think my general question right now to Justice Carpio is, I think there was a very good cooperation between the judiciary, the legislators, and the executive branch when we filed the arbitration case. The question right now is, how do we sustain it so that we could come up with a very concrete, concise, and an implementable vision for our country on where do we want to really go as a maritime country. Because right now we're talking about the West Philippine Sea, which is partly disputed, but we have not actually fully explored other areas which are not actually disputed, like the Benham rights, which was actually granted also to us under UNCLOS.
Yes, I think, in other countries, they have a dedicated agency that attends to their ocean affairs. And they plan ahead. How do we utilize the resources of the sea? How do we defend our resources? We don't have a dedicated agency doing that. So I think we have to now, because first we have to file also our extended continental shelf claim in the South China Sea. We have not done that yet. Now that we have an EEZ secured, we are entitled to an extended continental shelf, an additional 150 nautical miles. But we have to file our claim, and we have to prepare for that. So I think, and also, long term, how will we exploit our natural resources? I mean, what will be the sharing so that the benefit will go to the people, will redound to the people? How do we conserve the fisheries so that the fishing will be sustainable? So I think we need an agency dedicated to our ocean, because we have our resources in the sea constitute an area larger than our land area, several times over. We have denuded our forests. There are no more resources above the ground. Our mineral resources inland are about to be exhausted also. The remaining resources are in the sea. So we have to think ahead, how do we exploit it so that we will benefit from it? So I think we need an agency to do that. Thank you.
So we'll have our last three questions.
Okay. Justice Carpio, you mentioned the cases of the United States versus Nicaragua and Russia. Now, as examples of countries which either to compromise or through some face-saving mechanism complied with international agreements. Do we have an example of China behaving in the same manner? Because while it has signed apparently international agreements, from its behavior, it does look as though it is behaving like a rogue state, not so much as a state that abides by rules.
You know, when we filed the case, China said it was an unfriendly act because arbitration is not the Asian way. You do not sue your neighbor. But if you look at it, China is a member of the World Trade Organization. It has filed at least 10 cases. It initiated at least 10 cases against other countries, arbitration cases, the third highest among all countries which are members of the WTO. So arbitration is, they're very familiar with arbitration. And right now, Beijing is being promoted by China as a center of commercial arbitration. They're inviting foreign countries to do their arbitration in Beijing. So they have accepted arbitration. So it cannot be, China cannot say arbitration is an unfriendly act. In the first place, the UN Charter says arbitration is a friendly and peaceful settlement of dispute. Thank you.
In my readings of, I believe there were 3 instances, but this is not a maritime dispute, but a land dispute, wherein China was even very generous in some concessions and in trying to resolve a particular border issue. So if that would be an indicator, then I would argue that this can be resolved as well using that empirical data from history or accounts of 3 countries that negotiated with them on land borders dispute.
Good afternoon, sirs. I'm Attorney Jesus V. Hinlo Jr., the representative of Secretary Ismael Sueño of the DILG. My question is this. As admitted by one of the panelists, there will be a lingering question as to the relationship between China and the Philippines, and there's a presumption that we will have a hard time with the relationship with the said country. Now, was also admitted by Justice Carpio that it is in the DNA of the Chinese that they believe that the West Philippine Sea is part of their country. Just like the Filipinos, we also believe that the said area is ours. With 2 conflicting beliefs coming into play, there is no resolution. Now, as practice in our court, there's such thing as dispute resolution. We have to agree. Now, so what is the formula? Under the present proposals coming from our panelists, they don't have any formula except for the parties to talk. But when you talk about sovereignty in the table, there is no solution. So why don't we think outside the box? Why doesn't the party proceed by agreeing that the issue of sovereignty be placed on the parking lot? And the 2 parties now talk as how to have economic development for both sides. We have a problem with our fishermen, thinking that they are left out with the solution, no matter what will be the suggestion of the government to give them temporary compensation, but we cannot even assure them that it will last only for 2 years. It could last even after the Duterte administration. So why doesn't the 2 countries proceed and talk by agreeing first that the issue of sovereignty will not be touched? In so doing, the constitutional prohibition for the Filipino side will not be violated. And we will have a solution right now to the domestic problems facing the Philippines. Our president is garnering high ratings. I believe it's 91%. He has the trust of the Filipino people. If he can solve the remaining problem, which is poverty, and not only crimes, by having a peaceful dialogue with our neighbor and neighbors by bringing economic development to the country, I don't think we will have problems at the domestic front. And again, to repeat, for as long as the parties do not talk about sovereignty and agree on economic matters for the development of the area, it is my personal belief that the Constitution will not be violated. And I believe during the campaign, our President has told us he will never allow the Philippines to be a battleground among superpowers. It is not to our national interest. The national interest of the Philippines is different from the national interest of the United States and the national interest of China. The Filipinos must remain safe. We should not be like another Libya, another Iraq, or other countries in conflict, because war is the last solution. We should have peace for our people and give them the economic development that they rightly deserve. Thank you.
Well, the sovereignty issue is separate from the maritime issue. In the maritime issue, China has ratified UNCLOS. There's a dispute settlement mechanism, and we went to UNCLOS to comply with that dispute settlement mechanism. And the result is a ruling in our favor. On the territorial issue, sovereignty issue, we cannot sue China because there is no body that has jurisdiction unless China agrees. So we have a ruling on the maritime issue. We have to separate the two because they are governed by different rules. So in the maritime issue, because the EEZ is called exclusive to the Philippines, then it's ours. And that was affirmed by the tribunal. If other countries want to participate in the exploitation of our EEZ, they can under Philippine law because it's ours. Now, China doesn't want to participate under Philippine law. They want to participate under Chinese law. That's the problem. But we cannot agree that the exploitation in our EEZ will be under Chinese law. On the territorial issue, that's just small. The territorial dispute is very small because you're just looking at a small, tiny island or a rock in the 12 nautical mile territorial sea. There's no oil or gas in those areas. The gas is in the reed bank where there are no rocks or islands above water at high tide. And since these are maritime issues, since there are no rocks or islands above water at high tide, sovereignty is not an issue. These are maritime issues.
Justice, when an ordinary layman talks about sovereignty, it could mean that it talks about the territories or the rights preserved under the Constitution or guaranteed by the Constitution, to include the exclusive economic zone, which is part of our laws. Now, what is being suggested or proposed, if it is for as long as the Filipino public or a good majority would allow it, is that we, on matters such as those things, we can have it placed on a parking lot. The parties agrees now to joint economic development. And if we follow the point of view of China, in so doing, they will also think that they're also violating their law if they will claim to allow us to develop an area which they believe is theirs. On the side of the Philippines, we also think that way. As what I have said, our training in court, there are two conflicting ideas. If we become too legalistic on the matter, what we believe is legal may not be necessarily true with what the Chinese believe so. They also have a different interpretation because they will base it on their own laws. And as pointed out by the good justice, it is in their DNA. They will die for what they believe is theirs. Just like the Filipinos, we will also die with what we believe is ours. But the point is, can the public or can the government to include all of us here agree that the bottom line is for the national interest and we want peace, we want development. Let us not talk on sovereignty. Let us not talk on the strictness of the laws, of our interpretation of the laws as to economic zone, because it may have a different view from the other country. Let's talk of what is good to the Filipino people. Thank you again.
China has offered development not only to the Philippines but also to Vietnam, Malaysia, and Indonesia. And none of these countries has accepted because China said joint development means that you concede sovereignty to China. That's why nobody has accepted, not even Vietnam, a communist state. We have sat down with China several times. In fact, they offered joint development of the Reed Bank just before we filed the case, but it says there that they can tax the operations in the Reed Bank. That means they can exercise sovereign powers over the Reed Bank. And I don't think any president will accept that because he will be violating his oath of office to defend the Constitution, to defend the national territory.
You know, it would be okay to speak about putting things in the back burner and putting it in the garage or a back parking lot if there were no decision. But there's a decision to go by. And we can't just pretend that no decision has been laid down and say, let's talk to China as if no decision ever took place at all. In fact, a very serious constitutional issue would arise if we would give up our rights, sit down at the negotiating table and pretend that no judgment was ever issued in our favor.
And also, if I may add, precisely the arbitration case that the Philippines filed against China is the result of the breakdown of talks, or there wasn't even any developments really, because China always began with, okay, you should accept our indisputable sovereignty over these areas. That's always the dialogue or the monologue of China. Therefore, there were really no talks even in a loose sense. No? So that's why we filed this case. So that's really the perspective. We should understand it from that perspective. We tried to talk ever since '95, if I'm not mistaken. There were a series of talks over the years, over the decades, and these failed precisely because of their extreme position, because of their DNA or whatnot. And therefore, we filed this case and we won, and we should proceed from that paradigm.
That's correct. In 1995, when China seized Mischief Reef, we sat down with them. Every time we sat down with them, they would say, there's nothing to discuss, we have indisputable sovereignty. That's what happened in all our negotiations from 1995 to 2012. In 2012, they ceased against Scarborough Shoal. If we sit down with China again for the next 17 years, they will say the same thing. So we had to break the impasse by going to a tribunal authorized under UNCLOS, to which China has ratified, to get a ruling, if that is correct, that the 9 dash lines gives them sovereignty over the South China Sea. And we've gotten that ruling, so we're willing to sit down again with China. You know, China says, we will share your EEZ, but our EEZ is exclusively for us. What is ours alone. What is yours, we negotiate. That's why the Vietnamese accepted joint development. Malaysia hasn't accepted, not even Brunei. Indonesia will not. Thank you.
Okay, second to the last question, please, the young man. And to be last question would be the gentleman on the other side, please.
Yes. Hi, I'm Glenn Ongpin from the UP Diliman Engineering Student Council. I'd like to ask, what can we expect any support from the US and our other Asian allies? And if so, what kind of concrete support can we ask or can we expect from them to help enforce this ruling? Thank you.
Well, first, as I said, on freedom of navigation of our flight, that is in the national interest of the US. They will enforce that part of the ruling. We also have our mutual defense treaty with the US, which says that any public vessel of either country that is attacked in the Pacific area, which includes the South China Sea, will trigger the operation of the Mutual Defense Treaty. That's why we have this dilapidated ship, Sierra Madre Beach in Ayungin Shoal, manned by 7 Marines, and we still carry that in the roster of active naval vessels of the Philippines. That's why the Chinese know that if they attack that, it will trigger the operation of the Mutual Defense Treaty. So they're not attacking it, they're just waiting for the superstructure of the ship to collapse. So there is that Mutual Defense Treaty. But of course, the US has said we do not take sides in territorial disputes in the South China Sea. That's why when China seized Scarborough Shoal, the US said we do not take sides. So as far as the island issues in the South China Sea are concerned, the US said we do not take sides. Thank you.
Good afternoon. I'm Eric Sanuan, a former National Security Director of the government. I think we have to distinguish between the Xi Jinping administration and the Chinese people in this nation. Let's put everything in a proper perspective. We're not fighting China. We're just claiming what's due us. Neither does the totality of the Chinese people want war. And no Chinese people in his right mind will want to destroy the acquired wealth and infrastructures they're enjoying now. But we haven't seen the big picture of it because Bloomberg exposed President Xi Jinping and his family and his relatives. And despite the rosy picture their propaganda machines are doing and pretending to be anti-corruption themselves. But his family and his relatives are clearly exposed by Bloomberg as such as also corrupt family. And we have to remember the statement of President Deng Xiaoping in the past when he was invited by the United Nations, dated April 10, 1974, when he said, "If one day China should change her color and turn into a superpower, if she too should play the tyrant in the world and everywhere subject others to her bullying, aggression, and exploitation, the people of the world should identify her as social imperialism, expose it, oppose it, and work together." So what I'm talking about? So it's clear that the world should support the Chinese people and follow the famous quote of Deng Xiaoping in the process. Thank you.
So would any of the panelists would like to say final statements or words? May I please say them now?
I always believe that the Philippines is the only country in ASEAN or in the region whose assimilation of Chinese is seamless in terms of becoming a citizen or part of the community. And there is a joke that if you scratch the skin of every Filipino, you will find Chinese blood flowing in their veins. And of course, in our history, for more than perhaps 500 years in our attempt to establish a nation, there's been this constant engagement from all the islands of what we call now the Philippines and China. And perhaps what I'd like to point out here is that it is a fact that China is our neighbor. And by this fact, we should be trying to anchor the solutions of the probable, perhaps difficulties that shall arise further out of the ruling of the tribunal. And going by history and the harmonious relationship of these two countries, and we are always saying that the relationship is not only anchored on what we have been debating on the West Philippine Sea and what they call the South China Sea. I still predict that no matter how hard this problem is, we shall be able to find solutions. But I'd like to also place my takeaway is solutions must be based on, and it should be anchored on the decision of the tribunal.
Yes. President Ma of Taiwan belongs to the, he was the former president of Taiwan. He belongs to the Kuomintang Party. The Kuomintang Party was the government was a party in control of mainland China in 1947 when the 9-dash lines entered. And when the mainland in 1949, they carried with them all the records of the 9-dash lines. And in 2014, there was an exhibit in Taipei of the records of the 9-dash lines, and President Ma was the speaker. And President Ma said, the 9-dash lines are not a claim to the entire South China Sea. We just claimed the islands and the territorial sea, because at that time, there were no exclusive economic zones. So it was just a claim to islands. Now, Taiwan filed an amicus brief in the arbitration in The Hague, and they claimed for Ito-Aba, they control Ito-Aba, they claimed an EEZ in accordance with UNCLOS. They never claimed historic rights. Taiwan never claimed historic rights for Ito-Aba. They never mentioned historic rights. They just followed UNCLOS. So there is now a divergence between Chinese mainland's interpretation of the 9-dash lines and Taiwan's interpretation. Now, we have to remember that the 9-dash lines were invented by the Kuomintang Party. So there is a divergence. And I think eventually the Chinese people will understand that the 9-dash lines were never a claim to the entire sea, because that was never the intention. And President Ma himself said that. And in their pleadings before the tribunal, they never claimed historic rights for Ito-Aba. They claimed only maritime zones under UNCLOS. So it will take time. That's why I call this an intergenerational struggle. With that ruling, it will be easier for us to convince the people of China. Eventually, you know, their scholars understand this. They know. But those who were taught only that we were the owners of the South China Sea since 2,000 years ago, they believe it. But there are no historical records at all. So we have to expose that. Thank you.
Thank you. Thank you very much, Justice Carpio, for such a lecture and for the final comment. Likewise, we would like to thank the panelists for their response to the various questions. At this point in time, we would like to call on the President and COO of Trident Defense, Attorney Christopher James Purisima, for his closing remarks and to give out the tokens of appreciation and memento. Attorney Purisima?
Let us all give him a warm round of applause, please.
Thank you again for attending. This will just be very short now. We're very encouraged by your interest, by your attendance, and we will follow through with future discussions, because this is a never-ending topic. It is intergenerational as characterized by the good justice. And we will continue with smaller roundtables, smaller kapihans, so to say, even monthly if possible. And we already have a lineup of possible topics following through from this ruling, which we have to inculcate in all of us, in all citizens, and even citizens of the world. And so at this point, again, thank you. We'll have snacks afterwards. At this point, I'd like to present our tokens of appreciation. Actually, if I may just present this, we commissioned a t-shirt. I guess we underestimated the count here, but well, we commissioned a t-shirt that has that says Pilipinas with the alibata, the baybay, the ancient baybay of. So we will present this to our panelists and to our guests, and perhaps if anyone else would want, then we'll just leave us your email and we'll send them to you. So thank you again, and we'll present this to our panelists. So again, thank you everyone. We have snacks outside and feel free to stay.